guess we got one more minute before it's afternoon. Anybody know where the steak is? Prepared to mess with lots of lawyers. Jake's case. Invite him to come back to court. Yeah. Thank you. Thank you. between the state not being here yet and the fact that apparently none of the defendants have been fed lunch yet, we're going to break, let them quickly be fed, wait for the state to get here, and then get started. So we'll be in recess before accomplishing a single thing. right, so I think that maybe the first things we need to tackle are whatever the evidence is gonna be with our next few witnesses following Mr. Copeland. So I know that, co-conspirator statements, as well as all of the other evidence that y'all, the state intend to introduce with the next several witnesses has been provided now in detail. So I would propose that that's where we start unless somebody thinks something else would be more efficient. That work for everyone? Okay, so, have y'all been able to get together on any of it to come to agreement on anything, or are we gonna litigate all of it?
Your Honor,
Yeah.
just for clarity, are we discussing the evidence that was shared by Mr. Atkins on Friday night? Is that?
I mean, I think there have been a couple of different shares. There was, I also don't off the top of my head know exactly when. There was one, and then there was a supplement, and then there's also, I think, something that Ms. Hilton shared that's in a spreadsheet, which I think covers the same things that Mr. Atkins provided already.
So I think there's multiple, God bless you, there's multiple things. We sent the evidence regarding upcoming witnesses a few weeks ago, according to Mr. Atkins. What we sent on Friday, Your Honor, was the co-conspirator statements, making sure that the ones that the state intends to use were provided. And then yesterday, what I did was I provided a spreadsheet of the co-conspirator statements that are found within Mr. Garlington's wiretap, which had already been provided, and Mr. Sumlin's wiretap that had already been provided.
Okay.
So I just specified which statements from those wiretaps we intended to use.
Okay, so that's a subset of the bigger stuff.
Yes.
So, I mean, we can start there if y'all wanna start there, or are those gonna come in later in the trial?
Those are gonna come in later in the
Okay,
trial.
well then we'll set those aside for now.
Is the 31 through 60 witnesses.
Right.
Oh, I'm sorry. We submitted the 1 through 30 witnesses on August 8th, 2024.
Judge, there was one matter with respect to the PowerPoint. I did send over the redacted one. And I spoke with, as I informed the court, I spoke with Mr. Williams about Mr. Ryan's statement and our intent to not use that.
Right.
So those two matters were off the table.
Okay, so yeah, we don't have to deal with a motion to suppress Mr. Ryan's statement because the state does not intend to use that. And I've also been informed that Mr. Kendricks is not going to be filing a motion to suppress the first hour and a half or 2 hours or whatever of his statement. So we don't have, that's also off of our to-do list.
Your Honor, on
Yes.
behalf of Mr. Ryan, and what was received on Friday, I think was our updated list of the people they actually intend on calling and co-conspirator statements, I believe. So we'll have Mr. Ryan's motions eliminate the basic ones of this is inadmissible hearsay, those types of items based on what we just received. I don't know if those are any immediate upcoming witnesses. We're gonna prepare as fast as we can. We're just gonna, getting a rolling, this is what's actually being done.
And so we, in my speaking with Mr. Williams, I did let her know that if she had specific objections, there may be things that we could agree to. She did name some and I agreed with her. So we were continuing to discuss those. So if after those conversations, Ms. Abbasi and Mr. Williams feel like there's still more to litigate, that'll happen. But that conversation and that dialogue has started regarding those things that have been turned over to Mr. Ryan.
I think what probably would be the most productive is things that we have issues on, we make note of and make a record, this is the defense raises this issue, state agrees, so that they've been addressed and it doesn't, something got missed from the list or something like that. So we'll
That's-
get this done.
That's fine,
We'll
that's
get
fine.
that to the court as soon as possible. I don't know if they're in the next few witnesses category or not.
I mean, I don't either right on hand, but if it is, we're litigating that stuff this week.
Right, and the state, probably a little bit of guidance.
No, Your Honor, the stuff for the Jamari home are not within the next 10 weeks.
Okay.
Oh, thank you.
Sorry. That works. How about, Mr. Kendrick's statement that there's the Bruton issues on, right? And when's that gonna get introduced?
So, not in the next 4 weeks, actually, based on who it is that we intend to come before the witness that would
Okay,
introduce.
what witness will that be with?
Investigative Thor.
Well, y'all got him listed as witness number 5.
We do, but he has had, he will be moved down based on some circumstances that have occurred in his,
Okay.
he has some personal matters.
Okay, so is it still gonna be Burnett, Sledge, Zachary, Dean, Morton, Sprinkle, the phone custodians, Bernie, generally?
Generally, yes.
Okay, and then I guess Stork will be at the end of those now? Okay. And that PowerPoint, that's
with Dennis.
that's with Dennis, okay. So he's several out. All right, so great, that'll give y'all some time to get together on that statement to sort Bruton issues. Mr. Steele, you also seemed to kind of be making a broad argument that nothing in his statement, in Mr. Kendrick's statement, even if it doesn't directly implicate your client standing alone, needs to be redacted, or there needs to be a limiting instruction about that. Do you have any law to back that up?
Trying to get proper law, but in this case, there has been over objection, the announcement that YSL is a criminal street gang that Mr. Williams, according to 3 supposed experts, is a member of, in addition to Tritavia Stevens, said that Mr. Williams is a member of, in addition to Mr. Walter Murphy, and Mr. Williams allegedly as a member of. There may be others. And then in Mr. Kendrick's statement to law enforcement on October 6, 2015, he discusses YSL, the crew, the gang. So I think that under Bruton, it's an element of the offense of criminal street gang as well as RICO, that I believe that does not indirectly, but directly implicates Mr. Williams. But I'm looking for law on that. With that, I do not want to waive that issue. In addition,
Well, yeah, just to get me some law and we'll take it. Sounds like it's not quite as time sensitive as we thought it was, but we still need to get moving on it. So try to give me the law that would cover that.
in addition, I'm sorry.
Go ahead.
No, I thought.
Go ahead, I'm done.
That's cool. Yes, I do want a limiting instruction, and that comes right out of the cases that I did cite, because that statement I cannot cross-examine. Mr. Adams cannot cross-examine Mr. Kendrick. That statement should be his alone. And it's confrontation clause, so it does not move the conspiracy forward. So it's not a recognized exception.
Okay.
So the second part of the question was, do you have law for the limiting instruction? And I already provided, I could provide more.
Okay. And then I do want you to get with the state to try to come to an agreement as to what needs to get redacted to avoid Bruton, at least the classic Bruton issues, and we'll have to check out whether any kind of talk whatsoever about YSL gets included within that or not. But as to sort of the classic, you know, Mr. Williams did this, which I doubt if he says something like that anyway, but something that would directly implicate your client standing alone, y'all, the state ought to know what that would be and be able to redact that out. And it's gonna be played as a video statement, right? So, right or no?
We intended to ask questions
Okay,
versus.
that's fine. That's fine.
And Your Honor,
Yeah.
I did that in my motion. I was specific and I get the timestamp where it starts. And I did it not only for Mr. Williams, but I did it for anybody else that I saw. And I did it for Shannon Stillwell. He's mentioned a great deal
Okay,
as well. So I believe that I flagged, if I missed anything, obviously, I'd like somebody to tell me, but I believe I've already done it. If the state agrees with it, then we need to figure out, make sure that the witness or witnesses know.
sure.
But other than that, that's been done, Your Honor.
Okay, thank you.
Hey, John,
Yes,
while we're on this topic, just an additional issue. Not only are there Bruton matters, but there's also just typical evidentiary rule matters such as speculation. At one point, Mr. Kendrick is asked who he thinks may have done this, for instance, and he names some names. That's the sort of thing that would need to come out, Bruton or not, if we're asking about speculation.
okay, well, it sounds like it's not gonna be played as sort of a running statement. It's gonna be more targeted questions to the, I guess, investigator that conducted the interview.
Correct.
Okay,
So
so,
that would not even be an issue, putting in or trying to redact out.
okay, good. All right, so let's turn to some of the specific then, evidence that's gonna be coming in with these next witnesses. So there's not anything controversial with regard to witness Burnett's evidence, right? And everybody else is silent, so I'm gonna take that as a no for everybody else. All right, so Mr. Sledge, there are some co-conspirator statements from him. We already did his interview, right? Okay. Did we do his jail calls, or do we still need to do that? Maybe I can look at the more detailed exhibit list that y'all provided to everybody.
Your Honor,
Yeah,
before we discuss the jail phone calls, I do have one possible issue. I'm not sure how the state plans on doing this. I see what is this, the fifth row down on Mr. Burnett, comparison photo infinity Q5 or Q50 in gas station still photograph. I don't know exactly what that means or how the state anticipates that presentation to go in court. I don't know what Mr. Burnett's qualifications would be to compare two photos. So I'm just wondering how the state anticipates that playing out in court.
so are you looking at the first 30 witness list? Is that what you're looking at?
I believe I'm looking at the same thing as you. It starts with 81 and then Copeland under the witness.
No, I think you've got a more detailed one than I do. I need to find a more detailed one. That was a Dropbox link, right?
Correct, Your Honor. And in regards to what Mr. Shard is addressing, Mr. Burnett, both back in, I forget the exact date, but during Deputy Sprinkle's investigation, he worked at an Infiniti dealership. He's worked for Infiniti for over 20 years, so it's lay opinion testimony. Obviously, the state has to lay the proper foundation when he's on the stand, but
Right.
his ability to recognize Infinity vehicles is through his 20 years, and he personally has driven Infinity cars. So obviously that has to come out, but it's not scientific expertise, it's
He's
just
an
classic.
expert because he's got all kinds of daily experience with it from the last 20 years or
Yes,
so.
Your Honor.
Okay. Okay. So does that answer your question, Mr. Sharp?
It does, so I guess, Mr. Atkins, you are gonna ask him in front of the jury to compare the two photos and testify whether they're the same type of car, is that?
Correct, Mr. Sharp. As one piece of his testimony, I mean, essentially, after the foundation is laid, he will use his lay opinion as a 20-year Infinity rep to state his opinion of what specific vehicles are in both exhibits admitted and, demonstrative photos that are included in that Dropbox link.
I don't know, I would like the court, Sovereign Court, to look at the photographs. I don't know if we need a individual lay person to say that these are similar.
You, Mr. Atkins, are saying lay, but then you're describing something that I would think if this is beyond the ken of the average juror, it's expert, even if it's based on his 20 years as an Infinity rep. So which is it?
So, Your Honor, he can be, his experience as an Infinity rep, if he needs to be deemed an expert to state what the vehicle is in specific photographs, it's all through his training and experience of working with Infinity's hands-on for 20 years.
Okay, well, that would probably then be expert, but do you want to show me what it is that y'all are, I see that one of the things listed is comparison photo, Infinity Q50 and gas station still photograph. Is that what you want me to look at, Mr. Spiel?
And Your Honor, some of these
Yeah.
exhibits, so there's the exhibit of the drive-by shooting that resulted in Mr. Thomas's death that is at nighttime.
Uh-huh.
And there's also a lit up the Texaco gas station that's like 50 feet from the crime scene location. So that Infinity vehicle, in the state's belief, is the same vehicle seen in the kind of more lit up gas station and also the vehicle that did drive-by shooting. And so it is not as easy for just a juror to decide, because of the quality of this 2015 surveillance video, what kind of car that is driving down in either of these.
So are you gonna have Mr. Burnett look at the darker, more grainy drive-by and say, I can identify this as an Infinity because of X, Y, and Z things?
Correct, Your Honor.
Okay. And then you're gonna have him look at the same thing in the gas station photo and say, in my opinion, this is the same Infinity because of X, Y, and Z things?
He will speak about the make and model of the
Okay.
vehicle. He won't be able to definitively say that's the exact same
Okay.
car.
But you anticipate he'll be able to say, this is the same make and model as the one shown in here, and here's how I know that, here's how I'm able to determine that?
Correct, Your Honor.
Okay. I mean, that seems legitimate, and then obviously the jury will be instructed, they can believe it or not believe it, but that seems okay. Okay. All right, so then we have Mr. Sledge and his jail call. Did we already do his jail call?
We haven't, I've listened to the jail call, I would object, to the jail call. It's Mr. Sledge talking to his fiance or wife, about what happened in court, and it's definitely not.
Relevance objection?
It's not relevant, it's speculation, it's definitely not furthering any conspiracy. I'm not sure why that would be admissible.
Okay.
We would not play that jail call unless there was something that Mr. Sledge said on the stand that contradicts something that he said in the jail call.
Okay.
So I mean, that's.
So that's just potential impeachment, that's not gonna come in during his,
Right,
okay.
right.
All right, well, I mean, it's still out there as impeachment if that becomes an issue. But we won't, yeah, it sounds like they agree. Okay, and is that it for Mr. Sledge? We already did his interview. So that's the only jail call.
Right.
Okay. All right, so then Mr. Zachary, and we've done both of his statements already. Jail calls and social media. Yes,
They're updated as a court to inquire whether there's an updated contact or address or both for Mr. Zachary. Somebody said that he's in North Carolina. I don't have any contact with that.
okay, can you provide, if his contact information has changed since y'all last provided it to the defense, can y'all provide updated?
So the last, time before last that we spoke with him, someone indicated that he was, but it appears that he is still in
The
the
same
same
place
location.
he was, okay, all right.
Hold on, can I ask this question? We were told that he's very ill. That's what I was told from the detectives.
Okay,
And I was told that he's in a hospital. That was dated June 4th, 2024. So we haven't bothered him at all. But
so,
it's changed. I heard what the state said. It's
Okay.
information.
We can discuss that aspect of him, at the bench or something like that. I don't wanna put personal information about anybody out.
I know, I agree. Is that something we need to come up now and discuss?
We can.
Okay, let's do that. So with regard to Mr. Zachary, on the kind of detailed witness list that starts with Copeland at 81, all you have listed for him is the 2 interviews. On this other thing that we all got several weeks back, they just kind of had the order of witnesses. You also had social media and jail calls. Is that something we need to sort through? Or do you not intend to use those anymore?
And to use them, we did provide the social media postings that he has.
Okay, that's in that other Dropbox, right? Okay, so let's go to that then, and sort out whether there are any evidentiary issues with regard to all of the things you think you might use evidence-wise with Mr. Zachary.
On the 8th of August.
The Zachary folder. So we've got a group of social media, and then we have a couple of, well, I mean, we probably should just make sure while we're here in this folder that there's not gonna be an issue about any of the rest of it either. But, let's all open up the social media folder first and, voice any objections to any of what is in that folder so that I can take those up. I mean, I can see, everybody can see them, right? As long as we are looking at the same thing. Which if we're all looking at the same folder, we ought to be looking at the same thing. And like presumably everybody has already looked at all of this, because y'all have it for a couple of, week, 10 days, 2 weeks, something like that. So are there any objections to any of these social media postings and screenshots?
Just as a general objection, Your Honor, it's not a huge deal with this first photo, but the way we've been doing it is any non-testifying witness, if they've made comments on social media, and I'm not talking about the poster, but just other people, we've been redacting that. Again, it's not a huge deal in this case. Someone no one trusted says, "Where you at?" But
Right.
generally moving forward with all the social media, we're gonna ask that the state redact anything that's not said by a testifying witness.
All right, and if there is some reason why that's relevant, you can bring it up, but otherwise, I think that's a reasonable way to go about it, so that's how y'all will operate.
Yeah.
Okay. All right, so beyond just that clarification, are there any issues with regard to the things in this folder? There are 23 different items in the folder. And like y'all ought to be ready to go with this. Because all week last week I said this is what we're gonna be doing, so. I can't tell whether y'all aren't saying anything because you don't have any objections or because you're furiously scrambling to look right now for the first time, which should not be the case. Okay. It is. Defense counsel, we're not gonna be able to take this amount of time before every, sub piece of evidence, because we have, as y'all know, a lot to get through.
As a group, our stance is a lot of these are just social media posts that do not touch upon any allegations. And we're just essentially most of these cumulative, irrelevance, 403. And so I know that Your Honor maybe didn't want to do it this way, but if we could maybe just put them on the screen and litigate one by one, I think that might be easier because there's several that are objected to.
Okay, so which ones are objected to, and we'll put those, we can all look at those.
2,
2, that's 2015-57, that one? Is that what you mean? When you say 2, you mean the second one in there, right?
the second one.
Okay, all right, and assuming the comments aren't there, this is for all of these, unless you tell me differently, this is a relevance and cumulative objection?
It's a relevance objection on this one in particular. From what I can see, it's video, it's very dark, but I presume it's Lil D. I don't know that for a fact.
Okay, that's fine.
Yelling about Club Crucial and cussing.
Judge, this video. If the objection is relevance. So if the court was able to hear what was being said, this was a public declaration by a YSL member on his social media page that it is Big Crucial. They're at Big Crucial, which is Club Crucial. The substitution of the C in crucial for the B is evidence of what our gang experts have testified to regarding what blood gang members typically tend to do. Mr. Zachary is referencing not only himself, but slime takeover at Big Crucial, YSL. They're using YSL jargon. It is evidence of the existence of the enterprise, the existence of the nature of the enterprise, the associations within the enterprise, and the gang itself.
Okay.
Your Honor, we've beaten the dead horse of B's replacing C's a long time ago in this case. The state has played numerous videos of young men like 13, 14 years old hanging out in a parking lot saying B instead of C. And I mean, at some point, this is just,
Okay.
We've talked about this.
All right, so is the point of this that it is from Mr. Zachary himself and it is relevant to his credibility as to whether you tell me,
So
why is it not cumulative?
it's not cumulative, one, because no one, I think in here is going to concede or stipulate that YSL is a criminal street gang. So one, the associations that, and the substitutions that Mr. Zachary, who is an associate and a member of YSL, uses that tie himself and YSL to criminal street gang activity and criminal street gang customs is relevant in
Okay.
itself. Mr. Zachary is an associate and a member of YSL who is testifying. The fact, unless they're going to stipulate to these things, to the fact that YSL is an enterprise and that this is the nature of the, of their behavior, of their actions, then none of this is cumulative when Mr. Zachary hasn't testified, and the jury hasn't heard from this witness.
Okay. All right, I think that it is probative, to show, on the issue of his credibility and what he may know about, the gang, because I assume that there might be some argument, oh, well, this is part of his plea deal, and this is something that occurred prior to any of that, that arguably shows his connection. Now, if the next, 22 all do the same thing, then we'll have a cumulative issue. But this is the first thing from Mr. Zachary that's not, him sitting on the stand saying it. It shows, so.
He didn't enter a plea, he's not.
Okay, all right. So, I'm gonna overrule those objections. What's the next, item that y'all have?
Number 3, relevance,
Okay,
and, yeah, relevance.
right. What's the relevance?
Judge, in number 3, out that Mr. Zachary's, social media name is YSL_Lil D. He is in the picture with Shannon Stillwell, I believe that's Demikion Garlington, in the back seat. Mr. Stillwell is, throwing up, the YSL sign. And what Mr. Zachary says in the post that is made on May 5th, 2015, all my dogs dirty, check for names. I mean, I think it's self-explanatory, but the association, the nature of the,
I'd ask the state to explain what they think that means. 'Cause
It's not self-explanatory to me.
okay,
I know my dog's dirty might be, but check for names.
well, that part, the check, check, what, all my dogs dirty, I mean, check. Names, but all my dogs being dirty is a declaration, by Mr. Zachary. And we would argue that it relates to him, his friends, his cohorts, YSL members. Mr. Stillwell seated next to him, Mr. Zachary, Mr. Garlington seated behind him. It is an assertion of who they are and how he perceives them as a group. He is associating himself with them. He's saying they dirty.
Okay, well, so the check for names part remains unexplained, but
I don't know why Mr. Zachary proclaiming all my dogs dirty would have anything to do with this case.
yeah, well, I mean, it might make something more primitive more likely than it would be without. So I'm gonna overrule that. It may or may not mean what she asserts it to mean too, but that's for y'all to argue. Okay, which one's next?
Number 5, relevance. And I'll just point out that we have already through 3 and 4 and 1 and 2 established that YSL Lil D is handled at this
Okay.
point.
Yeah, so we don't need it for that anymore, but here we've got stack of money and a firearm. He said 5.
I'm sorry, 4, I'm sorry.
Okay, well, looking at number 5s. Let me get back to number 4. All right. State. All right, 4's out. Is 5 next, or what's the next one?
I don't, unless someone else on the team or on the defense speaks up, I'm okay with 5.
Okay. So what's our next one we have objection to?
Number 6, there's no objection, assuming the proper redactions are made. Number 7, no objection. Number 8, irrelevant, and also, so 401 and 403.
All right, let's look at number 8. All right, they're not gonna use 8. I want y'all a little more ready to go tomorrow, okay? I feel like we're looking at them right now and making the determination, and that was supposed to be done before now.
Number 9, same objection. Well, relevance.
Response. And also, to the extent y'all can get together and agree like you did for a couple of the statements, that would save court time as well. Okay, see, this is 3 already that y'all objected. They said, yep, okay, we won't use that. So if y'all get together, maybe we can do more of that. What's next?
Number 10, relevance. 401 and 403.
So, this, I think we had made it, number 1, we may have already put in the picture, but number 2, it is, the association with not just Mr. Stillwell, here it is the witness in the elevator with Mr., or in the photograph with Mr. Williams. And I believe it was open, standing in front of them, and this was posted January 2nd, 2015, 8 days before the Diamond Thomas murder. And the caption is, at Rudy 372 at SB _ Living Lovely at Thugger 1 heart and the green snake emoji for the YSL gang. So our argument is that this shows an association.
All right, I'm gonna allow that over objection. Run the 403 analysis and overrule that. What's next?
This appears to be actually my client's post,
I don't know which number we're looking at.
11, where he's, I'm presuming, standing next to a gentleman that goes by Trouble, who I believe is deceased now and is, oh, okay, it's a different Trouble, I'm sorry. He is not deceased, but I don't know, his name has never come up in this case at all.
Okay.
So I don't know what the relevance of that would be.
Relevance.
Let's introduce this way.
Okay.
Number 12, I'm going to acknowledge that it shows Mr. Kendricks in the photo, which if they're gonna argue association, that's fine, but this association is being established through 12. So, I don't object, but
Understood. If the next 5 do the same thing, it'll be different. All right, so
and number 13 is relevance 403 as well. All it's doing is showing Mr. Stillwell, Mr. Zachary, and Mr. Garlington in a photo together. And this has already been, this association's already been established, I think in picture number 3 maybe.
So, Your Honor, understanding that the defense feels that one picture is sufficient to establish a photo, and at some point maybe past one is cumulative, but this particular picture has a caption on it, the date of it being 2/17/2015, from top to the pen to the grave, wherever life takes us. Y'all gonna forever be my little bros at 30DG at YSL little D. Y'all go and follow them, by the way. So, Your Honor, our argument would be that the caption itself is relevant and the date of the association.
I would think highly relevant. I'm gonna overrule the 401 and 403 objections. What's next?
Number 14 is a post by YSL Buck. That individual, to my knowledge, has not come up in this case at all. So
All right.
oh, is that Buck?
Yes, it is. Okay. All right, so are you,
I don't know what the relevance is. Buck's not charged. He's not testifying. He was mentioned in a incident from 2013. So I'm not certain what the relevance is of showing a picture of Buck or a video of Buck holding what appears to be a firearm.
Big boots, bitch. We ain't play long. That's how the blood bills. What they doing? That's how the blood bills. My motherfucking big bro snake.
If you hit play, the first person you see as they're talking about YSL being a little bitch is Quindarius Zachary. So that's further evidence with the gun. It's further evidence of the association and the nature of the enterprise and the nature of the association. One more. And also, underneath at the bottom, you see the hashtag YSL Real Slime with the snake emoji. This is this outward display of aggression, this outward display of, firearms. We would argue go to proof of the nature of the enterprise, the nature of the association, the nature of the gang itself, and the nature of the activities within the gang.
all right,
Your Honor,
yes.
I mean, you've been hearing that explanation for months now. The nature, we're talking about videos posted on the internet by someone who's not charged, that has in the video someone else who's not charged, who's cussing and pointing guns, and I think they say YSL in the video, that at this point, any probative value derived from playing this video at this point in this trial, after all the other videos that have been played, is marginal at best, and it's outweighed by confusion of the issues, prejudicial effect, and the like. I mean, it's just overkill, And all these videos, I'm not gonna say all of them, but a great number of these videos have absolutely nothing to do with the issues involved in this case. And that's why this case is taking so long.
Well, I mean, I think it is probative of the assertion that YSL is a gang willing to commit criminal acts. Now, how many, so this is Zachary, Buck, and who is the other, who's the third person? Do we know?
Not at the top of my
Okay.
head, Jordan, but I wanted,
Buck is asserted to be an unindicted co-conspirator?
yes, and to be clear, Buck has, not only has his name come up multiple times, he has been in video, he is, his voice was played over a jail call. He recorded one of the videos with Trontavia Stevens and Mr. Williams. So yes, these two are YSL Associates members. And also, just as to the point that Mr. Sharp made about the number of videos, the constant cross-examination and sort of rebuttal against this idea that it shows an association and the nature of the gang is that it's promotional, it's music, it's art, it's something that's not related to criminal street gang activity. So our position on that is unless there's this stipulation regarding that, which we assert that it's relevant to prove, that every time that they argue that a particular video is promotional or it shouldn't be taken literally, they are creating a need for the state to show the jury evidence otherwise.
Okay, do we have a video similar to this one in already?
No.
Do we wanna dispute that and point me to what is?
When you say similar, I mean, the state played.
I mean, not like a music video,
The
but,
state played, I believe twice they actually played it. About 13-minute video of young men talking about YSL and slime in a parking lot outside apartments.
are they pointing guns at the camera while threatening to do things in the name of YSL?
I'm being told that guns were pointed in that video.
And is it I don't mean a music
No,
video.
it's not a music video. It's a video of,
And who are the people?
it was Walter, it was Trontavia Stevens, Lil D, Mr. Williams, Walter Murphy.
But not Buck or Zachary?
Lil D, what was that? Okay, so Zachary, I'm being told, was in it. Buck was not in it. I don't know what is important about Buck.
All right,
honestly.
if y'all wanna tell me exactly what, exhibit number that is, or give me that to look at, but my inclination is that this sounds different enough and not cumulative, so I can look at it and, I may change my mind, but at this point, I'm overruling the 401 and 403 objections.
We'll get you that
Okay.
exhibit number. 15 is my client's undated Instagram post showing a picture of Mr. Zachary. I believe that's Mr. Zachary, although it doesn't quite look like him. I believe that's him. And he's standing next to a platter of pastries.
So I think that's a relevant subjection.
And cumulative, because the association has been shown.
Okay, what does the state say about that?
Judge, we don't have to use this initially. We believe that it could rebut a particular line of cross-examination, but right now we won't use it in our direct of Mr. Zachary.
Okay, so there may be some cross-examination about whether they went to a bakery one day and then this might be relevant, otherwise they're not gonna use it.
And Your Honor,
I'm kidding, I mean, it may be relevant to something else, but who knows?
so it's Mr. Stillwell's post
Right.
of Mr. Zachary. And, his commentary about Mr. Zachary is what we were looking at that was most relevant.
He's commenting my dripping. So he's commenting on his clothes.
Dripping in blood. There's a red jacket that he has on, and that jacket, our argument is that that's what he is referring to.
Okay, well, at this point in time, we're not gonna be using that one.
Okay.
What's next?
16 is fine, no objection.
Okay.
Yes. 17 is fine, no objection. 18, 401, 403, the association with my client has already been shown. Not sure, that's Your Honor, just so you know, that is Mr. Zachary and Mr. Stillwell, seated behind a bottle of liquor with large amount of cash on them.
So, Judge, this is, part of our indictment talks about the purpose, and I'm gonna just read the language. Obtaining money, as associates of Young Slime Life, the defendants conspired to associate together for the purpose with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity, including robbery, theft, and the unlawful sale of and distribution of drugs. This is Mr. Zachary posting large sums of money with Mr. Stillwell and asserting their unity. One thing about my brew, again, the B replacing the C, we all eat. So he's talking about,
Yeah, we're rolling in the day, we're doing well. Do we have other things that already showed us that are similar?
when you say some,
No, I don't know, I actually think there was a cumulative argument on this one, it was relevance and 403. Overrule, what's next?
Number 19 is
And who all do we have depicted in this photograph?
we believe that this is Mr. Zachary, Mr. Nichols, and the third person we're not certain about.
All right, this is showing Zachary and Nichols in the same kind of YSL pose with guns.
Showing, yes.
Okay. Your Honor, 403. So,
Highly prejudicial outweighs the probative value.
it does not overrule. What's next?
One, I believe it's Mr. Zachary and Arlington.
Okay.
That is who is shown in this photograph.
Okay.
Number 22 is Zachary Arlington.
Okay.
And number 23 is another picture of Mr. Zachary and my client, Mr. Stillwell, at some sort of arcade, sticking up their middle fingers. I would object to that. Relevance 403.
All right,
Cumulative.
Days,
Go ahead, what's the state's response?
6 days after the murder of Donovan Thomas, this post is made. We gangsta in every city we go.
All right, and this is 23, right?
25th. Oh,
20, which
yes,
one is
number
this?
23.
20, right. Well, just click that in. And the main objection is 403 on this one.
And relevance, and Your Honor, while we're at it, the state said, brought up the caption. I don't know why that caption would be displayed. That's the words of Lil D. Sure, he's testifying. I guess potentially that could be impeachment, but I don't know why his out-of-court social media declaration would automatically be admissible.
It is the assertion, the public assertion, the fact that it is made publicly to display their dominance. This is 6 days again after Donovan Thomas. We believe that they went out of town into another city following the murder of Donovan Thomas, and an assertion that we are gangsta in every city that we go. The fact that you made the post, that you put yourself out there with another YSL member in itself is evidence beyond the words that are spoken.
What rule of evidence would allow an out-of-court declaration by someone who's is not a statement of a defendant or a statement of a party opponent? I don't know what rule of evidence. They keep saying because he's saying they're gangsters.
I
Okay,
assume, is he alleged to be an unindicted co-conspirator? I would think that would be the rule of evidence.
Well, I don't know how this would be deemed in furtherance of a conspiracy.
Because it shows, number one, it asserts their dominance. It shows, it asserts their cohesiveness. We are gangsta in every city we go. It promotes their, hold up, it preserves, enhances, and protects their reputation, power, and territory by the posting of messages, images, videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf. It is literally a line that I just read is literally a line from the indictment. And so this post itself is proof of that assertion and allegation in our indictment.
All right, I'm gonna hold my ruling on that and we'll see what else we've got.
Your Honor,
Yes,
all of these that we're going through, there has to be some sort of foundation. I mean, if Mrs. Zachary says, yes, I posted something like that, then that would be bolstering, right? It would just work cumulative. If he says, yeah, I posted that, and this is the reason why, just because it's in the indictment does not make that assertion credible. So the witness has to testify to all this before it just comes in as an exhibit. Am I wrong?
well,
I
it
mean,
has
that's
to
what I
be
would
introduced
object.
in some form or fashion.
It has to be introduced, that part we agree, but not that it's not permissible or admissible as an item of evidence just because he says I did post.
Right. Okay, so I'll withhold ruling on that one. What's next?
That's all the social media is
Okay.
over.
All right, so.
Yes.
And Your Honor,
Yes.
exhibit number for that other video that's already been played is states 16 Oh, I'm sorry, 60WA.
Okay. If y'all have it handy and can just shoot it to Ms. Burstfield and I don't have to go through the former court reporter to find it, that would be great. If not, I'll try it the other way. All right, so let's look and see what else is in the folder for Mr. Zachary. Well, y'all can see the same things that I can see. Is there any objection to the other 5 items? I think one of them's, the last one's one of the interviews. So is there any objection to the other 4 items?
The second to last one,
Yeah, I couldn't open that one.
I couldn't
actually.
either.
So can y'all maybe share that one? Do y'all know the one we're talking about? I don't know, it may be. It's 3.95 gigabytes, so maybe. It just seems to be in a format that, okay, so it's the other interview. Okay, that's fine. All right, so then objection to the other 3 items. Anybody?
items.
Okay, and you're speaking, I guess, everybody else's silence is assent here. Okay. All right, so that's Mr. Zachary. Should we look at, is Mr. Sledge, let's look at Mr. Sledge. He's gonna be either right before or right after Mr. Zachary. Okay, let's see what's in his folder. All right, we've got a jail call folder, a social media folder, a tattoos folder, and then some other items. Have we already dealt with any jail calls for him?
Your Honor, that's the one that the state said they would only play for impeachment.
Okay, and that's the only thing in that, yeah, okay. So that's all right, and then how about social media? We need to go through his social media, I would suspect,
Yes, Your Honor.
okay?
Excuse me, Your Honor.
Yes,
I have 5 minutes before we can close this.
yes. Anybody else needs to use the restroom? All right, let's take a quick convenience break. All right, we're looking at the social media posts for Mr. Sledge. Which ones do we need to litigate? So for whatever reason, I don't seem to have let me see if I can find the numbers. They were a lot clearer on the last group. So give me a minute to find where the three is.
And Judge,
Yeah.
am I incorrect? I believed that we had gone over Mr. Sledge's social media post. We did not?
I don't know.
I thought that we had gone over them, some of them at least, and particularly number 3, if that's the one that's labeled State's Exhibit 397Y.
397. No, I've never seen that.
Where we talked about the fact that it was the night of Donovan Thomas's murder and that he was
Yes.
posting.
Yeah, I remember talking about it.
Okay.
We haven't reviewed this, and my objection to this is the state keeps inserting these January 10th, 2015 captions on these photos.
We don't,
If you look at every other Instagram photo, there's nothing like that, but then on these January 10th, 2015, they're inserted, and that's inappropriate in my estimation, and that's my objection.
Sustained. I don't think y'all need that. That's not what it really looks like.
that's fine, and we intend to show evidence that it was posted on January 10th, 2015, so we can take out that little square that's above the.
Hover, yeah,
Yes.
okay. All right, so that objection is sustained.
And number 4, the same thing.
Okay, they'll adjust that one as well.
And so Judge, as I said the other day regarding the other inquiry about that, as I'm asking the court, if we establish with the witness who caused that to pop out.
Right. Yeah, I would think that if you are having that witness testify, here, here's me looking at the social media and here's what I do to find out the date it's posted and this is what it looks like. Here's, when I have her. I mean, I think that's fine and you can show that, but I think the exhibit that goes out to the jury needs to be just what it looked like, not with the hover.
So if, no objection, to that ruling as to showing the exhibit with Mr. Sledge, right? Because he
Right.
wasn't the one that hovered.
Right,
But as to, for instance, ADA Sprinkle, who would have been reviewing it and who would have been hovering, screen grabbing what shows up when he's looking at a social media page is relevant, we would argue, relevant evidence of the date that it was posted that goes beyond the memory of.
all right, what does the defense say to that? Like, the proposal at this point is not to have the hover part with these witnesses who posted or whatever, but with the investigator or prosecutor who, I guess, was in charge of collecting this evidence and who confirmed via hovering that that was the date it was posted.
If my sense, the state keeps saying Mr. Sprinkle did it. I don't know that to be a fact. So if they produce the witness who hovered,
I mean, I think that's their plan, right, is to put Mr. Sprinkle on the stand and he will testify to that.
Frankel, Gaither, Dennis, whichever one, because there are multiple
Okay.
ones.
well, so that's my whole point.
So yeah, whichever, that will have to come in through whichever witness did the hovering.
That is what we're saying.
Okay. All right. What else?
number
5 is,
Well,
I'm going to object to number 5.
which one?
It's
I
it-
can't tell what number 5 is. These aren't labeled the same way as the other ones.
on your top right of your screen, do you have something that says 5 of 37?
Okay, yes, and they're also labeled, so that's State's Exhibit 399 Yankee, so that's the video. It's 399,
Okay, got it.
so
Do I need to watch the video? Because if so, I need to pick which media player
I
I'm
can,
gonna.
you can just, I can hit it, it's a regular one.
Well, I'm not on Zoom, so do I just need to
Oh.
hear it?
I think
I can join Zoom, but hasn't happened yet. So give me just a second.
Yes, Your Honor.
Do I need to see it or just hear it?
I think hearing it would suffice,
Okay.
that's.
The full screen.
You lied to your mom,
I just ordered.
but you get in the courtroom and tell the punk ass people the God honest motherfucking truth. Pussy ass.
I didn't stop it. Let me try it. It's loading.
Lie to your kids, you lie to your mom, but you get in the courtroom and in the investigation room and tell the punk ass people the God honest motherfucking truth. Pussy ass.
So,
I thought we did discuss this.
There was a prior video that's been admitted into evidence where this is my recollection, and Ms. Williams, if this is not correct, I apologize. Mr. Williams, we discussed this one as well? Okay.
Okay, so on to the next one.
I know, my next one I had object to is number 11.
Okay, can y'all tell me what the state is?
yes.
And number 11 is, it's State's Exhibit 406Y, and to me, it seems to be a collage of other photos with Mr. Sledge and other individuals that show up in other exhibits. There's no new associations that are revealed by
Okay.
State's
Is-
Exhibit 11.
All right, is the point of this one the post that goes along with it?
Yes, Your Honor, just one second, we're pulling it up. You got it? Yes. Just to put on the record what it says. I love my slimes, well, snakes, and they green heart emoji me. And it's a photo grid of Mr. Sledge and other YSL members. So, yes, the post and the association and the public proclamation of that association.
All right, so similar to when Mr. Zachary is himself saying, yeah, these are my YSL people and here's me with if we don't already have something, I mean, we may have these individual pictures, but we don't have this assertion yet by Mr. Sledge, then that is not cumulative, so that's admitted over that objection.
Number 13 has a similar caption,
What's our exhibit number for that one?
408Y.
Okay, thank you.
Has a similar caption, and it seems to be my client dancing.
Okay, so that one's a video, which I can't open. And I don't know why, even though I'm now on Zoom, I can see it on Miss Persifield's, but I can't see it on mine.
Ms. Hilton, if you could share via Zoom, that would be helpful.
Oh, there it is, okay. I got it now. Yeah. Are you gonna hit play?
Share the phone.
Yeah, if you wanna figure out. So this is yours. Okay, all right. Okay. Is there anything added to this one that isn't captured in the, still other than a good beat?
To create a soundbite. The still showing all of the members of YSL and the post are the most pertinent parts.
All right, so then, y'all don't really need this one, right? I'm asking, is there,
We don't need the
we
big,
just looked at number, was it 11, that was like the collage, are there people in this still or part of this video that aren't also in that collage?
Mr. Williams, I believe, but I'm checking to see in the
Okay.
collage whether Mr. Williams is
All
in
right.
the collage. Mr. Is he? You can't see his face in the collage, so the still shot is in the collage from the video in the upper left-hand corner, but Mr. Williams' head is turned away from the
Okay, so
camera
if you
in the
wanna
video.
capture a still from that video that shows Mr. Williams, then you can use it.
Okay.
Okay. Next.
Number 14 is the same thing,
14 is which exhibit number, 410Y or
09Y.
409Y? I thought that's what we were just looking at. Oh. Well, no, that's a different one. Okay, that seems cumulative. Unless there's some reason that the state believes it's not.
These are different people, and this is, can you hit play? This is Mr. Sledge, contact is right here, and Mr. Williams' sister is showing the association. It's showing, again, when they're talking about, I love my green heart, green snake, red hearts, emojis. We have jail calls that we have asserted are co-conspirator statements that involve Mr. Williams' sister.
Okay.
All of these same people are in.
I didn't know that this sister is the sister?
There's another exhibit, 405Y. The state, this is an unrelated trip to the club, and now we have 2 videos, a collage, and I think 2 photos
Okay, so,
documenting this night at the club.
okay, so which videos are, cause I haven't, unless there's some video that you just didn't.
Well, I didn't object to it.
Okay.
It's 405Y is a picture of everyone from that same night.
Okay, and does that show the sister?
I can't.
Does the state know whether the photo that's a big group shows Mr. Williams' sister?
Okay, two things. So I don't know that it's the same night as Mr. Sharps argued, but
Well, I'm
I'm
not sure
looking
that's
at.
relevant. If the point of it is to show their association, then whether it's the same night or not. Does this show Mr. Williams' sister with this, general crowd of people?
Okay, we're going back to 405, was it?
Yes.
This one? He says State's Exhibit 405.
Page number 10.
Okay.
Okay, well then, that video then shows something that's not shown already. So that video is number 14. So that's admitted over objection. What's the next?
410Y, it's some sort of meme that was shared by apparently Mr. Sledge. Makes no reference to anyone in this case.
So, Your Honor, the reason that this meme, we would argue, is relevant. You're about to get 20 years for a crime your best friend did last night. Do you snitch or take the beat? You tell the punk ass police to do their fucking job. So Mr. Sledge, in his interview, he essentially said as much. On his video that the court heard a moment ago, he intimated as much. But what he's doing in this particular posting is making a public proclamation displaying their belief towards snitching. You have not only Mr. Sledge making that lie to their mama and lie to their sister, get into court and tell the guys on his truth. You have Mr. Williams, who posted a similar video with Mr. Sledge apparently in the background, mumbling, saying, sort of signing on to whatever it was that Mr. Williams was saying at the time. We would argue this right here is more of that, this is who we are. We don't snitch. You let the police do what they're supposed to do, but you don't tell on your friends. And under the circumstances of this trial, especially considering some of the testimony the jury has heard, we believe that this particular type of posting, public posting, is very relevant to explain some of what the jury has seen.
Okay.
Two things, Your Honor.
Yes.
First, the state has said they have a video of Mr. Williams saying things about snitching and Mr. Sledge saying things about snitching. So this is cumulative. Also, the state keeps saying they feel this, they're saying this. Mr. Sledge owns and operates, presumably, his own Instagram account. At no point does he make any reference to anyone involved in this case. At no point is he saying he's speaking for YSL. At no point is he hashtagging YSL or at YSL, anything. He's making a comment as an individual on his individual page. And he's really sharing the meme, but I don't know why that's relevant. And it's certainly cumulative when the state just said they have other people. They have him actually giving a statement, and they have Mr. Williams giving a statement. That's already in evidence.
All right.
This particular assertion, it doesn't just say no snitching. It says you're about to get 20 years for a crime your best friend did last night. So the fact that Mr. Williams has made an assertion that is very similar in nature to the one that Mr. Sledge has made, and then the fact that this particular posting references not just telling on someone, but you're about to take the heat for something your friends did. It's displaying yet another message to the public about YSL and we would argue their willingness to stick together and stand on, their loyalty towards one another. The argument, I don't know that it's so much necessary to say that it's, it would be our argument that he is asserting the sensibility, the way that YSL operates. That's what we would be doing. It's proof, we would argue it's our evidence of the way that YSL sort of.
All right, I'm gonna
Promote it,
sustain that objection on 403 grounds. What's next?
413. Why? Is this the same video that was I believe 399 and 413 are the same, am I correct?
I don't know. Are those the same video?
Oh, I'm sorry, it's a different video, but he's saying the same thing. He says the same thing twice about snitching, things of that nature.
So, do I need to hear what this says?
Hey man, let's give it, say a lie to this kid, tell a lie to his mama, or get in the courtroom and tell the judge and God on the truth. That was pussy ass shit. We call your whole ass nigga strip now. Crack.
So, I think it's the same words. One time he's wearing a white t-shirt, it appears, and one time he's wearing a white tank top. I don't know why he recorded it twice.
We can just use this one, especially since he says black at the end.
Okay.
BLATT, black.
All right, so this one, and what's the number that you're not gonna use instead?
399Y.
399Y will be out then. Okay,
And Your Honor, the other issue is that posting it multiple times, posting their feelings about snitching multiple times, it is meant to reinforce how strongly they feel about it.
all right, so, what were the dates of the two posts? I had understood you to say that you wouldn't use the other one, but are you now saying you do wanna use the other one?
So we would ask, yes, to use both, because if one is on July 19th, 2015, and the other one is on, 399 is on July 19th, 2015. And the other one is on March 25th, 2015. We would ask to be able to use both.
Okay. Well, I mean, that does show that this isn't a one-time thing. I guess at least this guy wants to reiterate it, so, I will admit that then. What's next?
416Y. Relevance.
What's the relevance of this? So who else in that?
Martinez, Arnold, Demonte, Kendrick.
I mean, I can see the relevance. What I'm wondering is whether it's cumulative. But Arnold and Kendrick, I don't think we've had any, at least in what we've reviewed so far, the two of them.
They both pled together on a count in this indictment. I mean, there's gonna be absolutely no. No, not on this indictment, but there's a count in this indictment,
Right.
an overt act where they both pled.
Yeah. No,
So-
yeah, no, I'm saying that we don't have any videos or photos that we've at least looked at today that have the two of them wearing YSL garb together, right?
I don't think we have.
Okay, so
Not so far.
okay. Anybody dispute that?
I don't believe so.
Okay, then that will be admitted over objection. What's next?
Number 22, it's another video that I don't see the relevance.
Okay,
417Y.
thank you.
Bitch, we out doing a little shopping, bitch. How we having this shit?
Talk about saying, we can go here before, but we do a lot of the shot, man. Fuck, I'm stopping, sit in the shot.
Yeah, turn up.
So that was the extent of that. Was the court able to see it?
I mean, tell me who all's in it and why.
It's
Shannon Stillwell, Diamante Kendrick, Antonio Sledge,
Mhm.
and this is a couple months after Mr. Thomas's murder. Diamante Kendrick is in the coat that he is wearing the night of Mr. Thomas's murder. And they are still very much associated with one another. One of the arguments that was made the other day by, I believe, Mr. Sharp was he objected to part of the factual acknowledgement of Mr. Sledge and argued that he would have had no basis for personal knowledge of information that had happened on a particular night.
Okay, well, this might show that as a foundation, but that's not for the jury, that's for me. So,
No, I'm just, as far as relevance goes, it would be relevant for those purposes.
just seeing,
The co-counsel emphasizing that jacket being the jacket that he was wearing. Mr. Kendrick, if we need to rewind it, we can show you.
I saw it,
I don't believe that's the same code. I believe it's arguably similar, but I believe it's the same
how do y'all know what he was wearing that night anyway? What evidence is in or gonna be in?
It's on video. He's clearly walking into a store, that's a few 100 feet away from Mr.
And that's clearly him, and so what does it matter that he's wearing the same coat later? It's his coat, I mean, why does that matter?
No, just
I mean, seriously,
in terms of one identification, I understand that the court is saying you can see him clearly on the photograph in the surveillance video, but also he's with Mr. Stillwell, who is also alleged to have committed the act with him 2 months afterwards, and he's with Mr. Sledge. So when Mr. Sledge gets on the stand and tells the jury, or whether he does or doesn't acknowledge that he knows.
All right, well, so then this might come in as impeachment evidence, but I'm not hearing like, oh, yeah, no, we never hung out, or we didn't hang out after that night, because I was appalled at what they supposedly did, then yes, but otherwise.
And I'm sorry, and Mr. Kendrick filed an alibi notice as well regarding where he was at the time of the murder, so.
Okay, but it went, this has no relevance to his alibi.
Not directly, just that it's further proof that that's him in the video and him at the location and him right there 6 minutes before the murder.
Okay, so then back to the coat being the thing that matters, then.
Yes. Yes.
I guess if your client, Mr. Weinstein, is saying I wasn't,
He's not denying being at the gas station. It's in the video, you can clearly see that
Okay,
he's walking into the gas station.
what's his alibi? Then maybe I'll need to go look up the alibi notice.
He was with Miss Morton later that night.
So it doesn't cover the time of.
No, he was with Miss Morton at the time of the murder.
Okay, what
But
time?
what the coats have to do with this, I have no idea.
I
What
guess
the March video
It's,
has to do with his alibi on January the 10th.
right,
The time, he was,
but what's the time of the gas station video?
at the time, it was at the time of the murder. It was 6 minutes before the murder.
Okay.
Your Honor,
Now, hang on just a second. Sorry, and then is Mr. Kendrick's alibi that I may have been at the gas station 6 minutes before, but 4 minutes before, through the time of the murder, I was with somebody else somewhere else?
Give me 1 second.
Okay.
Yeah, and again, there's no denial that he was at the gas station prior to the murder.
All right, but not, okay, so the code doesn't add anything to that.
But it's not the same. He's like my wife, Your Honor. He buys the same style coat, but it's not the same.
Whether it's the same code or a different code,
Yeah, it's
it
irrelevant.
doesn't show anything about
No,
the viability of his alibi. And anything else before I exclude this one? No, okay, moving on, that was that.
23, Your Honor, the previous photos have 418Y have
Okay.
continued to show an association between Mr. Sledge, Mr. Zachary, and Mr. Stillwell. That's been established through the photos already.
All right, and who is this we've got right now?
That is Mr. Stillwell, Mr. Zachary, and Mr. Sledge.
Go ahead.
I would point out the caption that Mr. Sledge makes underneath the photo, gangsters sitting at the round table with 3 green snake emojis on March 4, 2015.
And those same emojis are what justified all these previous.
So is are you making the argument gangsters sitting at the round table is like a reference to gang Arthur the Knights the Round Table or what? Or just the fact that they're saying gangsters?
That they are calling themselves that he is calling them gangsters, because I believe at some point there will be, we've heard at least one witness while we were talking about gang, say game, like GAME. So I believe that there may be efforts to distance YSL members, well, there have been consistent efforts to distance YSL members from being gang members, gangsters. So we would argue that he is not just sort of making this, oblique reference. He's proclaiming for the public something.
The generic term gangster is propensity, first of all, but secondly, if Mr. Sledge says something on the stand that's vastly is shocking to the state and they feel that this contradicts it, then perhaps there's another discussion, but in and of itself, until that happens, I don't know why this would be relevant to anything.
So remind me, The one that gangster in every city we go, that would show the same thing.
You didn't keep it in.
I didn't rule it out, I
You
held
didn't.
it.
We would prefer this one over that one.
All right, then that one will be out and this one will be in then, but they kind of get to the same thing.
So, Your Honor, could the court give?
Sure.
We're going to choose, we would choose the one closer in time to Mr. Donovan Thomas's death. So we would cede this one. if the
All right,
court-
so then 418Y is out. And if it ends up being some kind of impeachment evidence, just sort of alert us before we use that.
Okay.
Okay. What's next?
Number 421Y, which is number 26. It's another group photo.
Mm-hmm.
This is a picture that's in our indictment. I believe we may have even already admitted the photograph, but the caption is also part of what is important. So both the photograph, the caption, and the fact that it's in our indictment alleged as an overact.
What do you mean alleged is an overact?
The posting of that photograph was
The
alleged as
posting
an
is
overact.
an overact.
Yes.
Okay. Then, and so, okay, you allege is an overact that they post things that promote YSL, and you showed this picture as an example, and this is showing that it was actually posted. Is that the argument?
Yes.
Okay.
I think that
And it's a cap.
Yeah, I can see what the caption reads. I'm gonna permit that one.
Okay, now, here is and when I say here, I'm talking about 422Y
Okay.
is the actual post. I'm not involved in hovering over anything. It says a date.
Right.
And I know the relevance of the date and the time. And so I don't have any objection to that, but that's the way I believe that these, not some manipulated timestamp on the upper right, but as it appears in Instagram. And so I don't have any objection to 422Y, but going back to that other
Right.
exhibit, which is 397Y, I would say 422Y is more appropriate.
Okay, and it actually, you can see down there at the bottom of the post a time and a date.
This is exactly like when we were talking about the other day where we had the picture with the pop out of the one we dealt with on Friday. We had both the pop out and we had the date and time. When I referenced to the court, we had both. So this is the same situation. So we would be introducing this one, and since it's no objection, we wouldn't have a need unless there's this argument about what date it really was posted to show the other.
Use the other one. Okay. All right.
So this next one, which is 423Y, that caption is already on 420Y. It appears that he's reposting something that some other individual who I don't know who he is, and I have no reason to believe that he's in this case, SMM body count with an X instead of a C, posted. And if you go back to 420Y, I believe, you see the exact same, I'll never switch up on my brew, I'm not a dub. So that seems cumulative, and quite frankly, I'm not a big fan, and I believe it's prejudicial to have a post by this gentleman, SMM body count, who we don't even know who he is.
What's the state's response?
I'm looking at that's fine, we don't object
Okay, so, they concede
or
that
concede,
they will
yes.
not use, what is it, 422, 423Y, 423Y. Okay. Thank you. Next.
So I believe that this is a cumulative,
Which one?
I'm sorry, 426Y, number 31, photo 31, is a cumulative of the group
Hang on, that
photo.
one doesn't open for me. Shouldn't think so. Okay, yeah, that looks like the same thing.
That's a cumulative of 405Y.
We're gonna put up both. We won't use both, Your Honor, we'd ask that the court allows.
All right, well, choose now so that we know which one.
The one that is 405Y.
Okay. All right, so they will not use 426Y.
Oh, wait, it's wrong.
Okay?
Don't understand the relevance of 427Y.
So there's a relevance objection to this one.
His, it's that he listed his phone number, and his phone number, by he, I mean Mr. Sledge.
Okay. So if he refuses to say what his phone number is or was at the time,
Or we
then
could refresh
we'll
it.
use it.
Right.
Okay. Which you could certainly just use it to refresh his
Right.
recollection. Okay, so that'll only be in that eventuality.
Or if he doesn't remember even after looking at it, then we would have to use.
Sure. All right, any others? We're almost to the end of this grouping.
Yes, Your Honor, 430Y, which is number 34.
I don't see a 430Y, but okay. Okay.
I think that's the whole, you know what I'm saying? I didn't have no respect for Barry. Chili don't get, see, like you crying.
How long do we have there?
Oh, yeah. Mr. Williams, we hear the reference to King Slime. Could you play it there? Sledge right there, Mr. Williams right there, Mr. Arnold, Mr. Stillwell, and Mr. Kendrick,
I think that's the whole, you know what I'm saying?
Darlington, and Kendrick,
All right,
and Cole, oh, Mr.
and when's this from?
This was,
And also whose account, I'd be interested.
Wait, I couldn't hear what you said.
I'm not sure we know whose account it's from either. Who is that? So I, the justification is, for these videos has been, oh, it's showing promotion, and we don't even know who posted this.
but we have the people who are in the video who can talk about the video, it's what's happening in that scene itself,
They're sitting at a table.
that he can lay a foundation for it.
Who, and this is gonna be Mr. Sledge that
Yes.
testifies to this?
Yes. And not, in this particular instance, this isn't so much as them promoting their violence. This is them referring to, we believe Mr. Williams is King Slime. This is them, all of them. I don't know that we have these particular individuals all at one time in a setting together. And we believe and can later confirm that it is Mr. Williams' Sky House condo, but we'll confirm that.
Okay. I would think that would be relevant. All right, so I'm gonna overrule the objection to that. What else?
Just 404Y, which is number 37.
And let me say, let me go back to that one for a minute. Sorry, since y'all don't know who posted it, I mean, if you figure out who posted it, that's one thing, but if not, we don't need to show the handle or whatever of whomever the poster is, okay?
Yes, Your Honor.
All right. Okay, now back to the next one.
It's the last one, Your Honor, 404Y, number 37.
All right. Have we already talked about this one? Oh, this is,
Stop putting out fucking fake things. Cause I don't give a fuck, man. What y'all say, what y'all do. Anybody wanna see me want to, I'm here. I don't hide. And I do not run for fuck niggas. You did.
So, Judge, this is the day after the Adele Drive shooting that Mr. Sledge and others were convicted of.
what's the objection?
I'm gonna withdraw my objection.
Okay. All right, so that is that grouping of social media. I think I might have to go back and get into that Dropbox again. All right, the next folder is tattoos, is what that folder is called. Or do we have objections to anything in there? I mean, it looks like a lot of them are the same picture over again. So at least I would think half of them, we don't need the same thing twice.
We wouldn't be putting in
Okay,
multiple pictures.
beyond that, Any objection? I mean, I assume he's gonna testify that all of these are somehow gang-related tattoos or what? Cause if they're just art, then that's not relevant.
We're not gonna put in all of, them, just the ones that, reference or pertain to his, I mean, he'll be here, so we may not even put him in at all, he can show the jury.
Well, I don't think I want him stripping down in court.
No.
So if he wants to show us one on his forearm, that's one thing, otherwise I'd rather let's use the picture, okay? I don't know, I can't get an answer to that. Do you know which ones you're gonna intend to use that you believe are relevant to an issue on trial here? That he can't roll up his sleeve and show us? Yeah,
I think we're not gonna need to use Mr. Sledge's tattoo photographs.
all right.
And, yeah,
Okay,
I don't think it's.
so I don't know what that, then there's an image that is, oh, it's a video that isn't in the other videos. What's that one? Is there an objection to that one?
Sorry, Your Honor, I just.
I mean, so I opened up the Dropbox and, you know, went to Sledge's folder and then within that folder,
Yeah, I'm sorry, I just clicked on it, I think that's the video. Is it the image?
yeah, 0156, whatever, yeah. So is that objectionable? Okay. Any of the other items in that, folder? And they're marked with exhibit numbers.
Is the court asking whether,
I know that the state's position, I assume, is y'all intend to use those and believe they are admissible. So I'm asking if there an objection to them.
So, the plea agreement, I've already
Okay,
talked about that.
yeah, and so, yeah, it's a little more helpful actually when I look this weekend to see what it is y'all are talking about. And I would think whether that comes in or not depends upon how that witness testifies. So
When you're saying that comes in, are you speaking specifically?
this, I'm looking at the, whatever it is, December 27th, 2022, several page. It's called plea agreement, but he's initial different factual assertions and that's the one I'm talking about. It's 396 YC, Y Charlie, Yankee Charlie.
Yes, Your Honor, and the terms of the plea obviously are filed for cross-examination.
Right.
I would concede that potentially, depending on his testimony, statements that he acknowledged that would be inconsistent with his testimony could possibly be prior inconsistent statements. I would concede that fact. So I agree with Your Honor that to deal with the admissibility of the factual acknowledgement section, we would need to hear his testimony. My specific concern dealt with number 8, and just as I had concerns about Mr. Zachary and Mr. Copeland, whether they were in their prior statements, whether they were speaking out of actual firsthand knowledge or if they were speaking out of inadmissible hearsay or rumor or speculation. I don't want Mr. Sledge to be cross-examined or to be impeached with a prior statement that was based on, that the basis of it was inadmissible to begin with. That's my concern.
Well,
And all I can say, and I'm not Mr. Sledge, so I cannot answer this for your honor, but I can say from my understanding from working on this case, that number 8 is not based on anything that my client has told him, and it's not based on firsthand knowledge.
I think that may just be something y'all have to explore, because he initialed and signed a sworn statement saying, I personally know this. Maybe he doesn't personally know it and it was a lie, but I mean, they've gotten that there for a reason. And that's just gonna have to be something y'all explore with regard to his credibility. You know, I mean, he is right here asserting in this document, I do personally know it.
Well,
So,
I understand what you're saying, and, you know, these are not, I understand he signed it, he did not write it. And so personally, knowing to a layman can mean a lot of different things.
yeah, he had an attorney at the time, right?
He did.
Yeah, so I think that, yeah, that, I can't keep it out on that basis. All right, what else?
We briefly discussed the plea transcript. I don't know under what circumstances that would be admissible.
I would think that would also be a impeachment item, right? Would y'all only intend that for recollection or impeachment? Okay.
Okay, and then we also have a gang profile, which is filled out by someone, I don't know who wrote this. I don't think we know, we've been given a bunch of these, I don't know if we know who wrote any of them, but it wasn't Mr. Sledge,
Right.
so.
We would not introduce the gang profile as an exhibit through Mr. Sledge. We may use some part of it to refresh his recollection or something like that. It would be, because it would be a document that details certain incidents that involve Mr. Sledge. And it has photographs of him in it. We wouldn't be just whole hog introducing that.
All right, so this is not gonna go before the jury.
Right.
Y'all may
We would,
potentially refresh his recollection.
it's just
over
that,
something like this. Okay. All right. Okay, that takes care of these Sledge exhibits, right?
I believe so, Your Honor.
Okay, so who do we move to next then?
listen,
Sorry, I have to keep reopening the Dropbox for some reason. Is there anything with, I know, looking at the witness list, we've talked about Burnett, Sledge, and Zachary now. Thorpe's gonna be moved to a bit later, so Bean,
not yet, Your Honor. There was one that we can talk about that I think merits conversation. So Mr. Kendrick pled guilty in 2015 when he was arrested with Martinez Arnold in October 2015, where they had the two guns, one of which was stolen. In the plea colloquy, the prosecutor, as a factual basis, asserted that YSL is a gang and that Mr. Kendrick is a member of YSL. And Mr. Kendrick acknowledged that and agreed to that. And so we intend to introduce evidence of that against Mr. Kendrick during the trial.
Okay.
We're absolutely gonna object to the entry of not only that colloquy, but any plea that reflects a gang charge that Mr. Kendrick pled guilty to. Mr. Kendrick, to my understanding, I mean, that's a decision he's gonna make, but I have no expectation that I'm gonna have the opportunity to cross-examine him. It was a testimonial statement. He was in court, speaking to law enforcement, for the purposes of securing himself the best deal possible. And, certainly his acknowledgement, admission, or his testimony, I would say, is what it is, out-of-court testimony, or out-of-court testimony as applies to this case, affects my client. A element of this whole case is whether YSL qualifies as a criminal street gang under the law. Mr. Kendrick provided testimony to that, that I will not be able to cross-examine. And so we are going to object to any entry of the plea to any gang count and any colloquy during the plea regarding the nature of YSL, according to Mr. Kendrick.
And Your Honor, the court can limit the jury to consider that against Mr. Kendrick only.
Go ahead.
That would be wholly insufficient to protect the rights of Mr. Stillwell and the others, quite frankly. Assertive instruction or limiting instruction is not gonna suffice. And, you know, the state can try to prove their case, but they cannot try to prove their case with Mr. Kendrick's statements during a plea.
Well, I'm not sure that's true. I mean, it is admitted only against Mr. Kendrick, and I am Kendrick's, and I tell them that that's all it can be considered against. We'd have to craft the right instruction, but I mean, it's out there and it's evidence, and I mean, I agree it's testimonial, and so it shouldn't come in against anybody other than him. It can't come in against anybody other than him, but seems that it ought to be able to come in against him. Are you saying there's just no way to limit it?
Go ahead, Mr.
Yeah, I agree with Mr. Sharp. That is asking a jury to climb a steep hurdle. And that's why Bruton says that, yes, you can limit the statement. It used to be, as the court may remember, on a Bruton issue, if Mr. Kendrick made a statement, he made a statement in this case on October 6, 2015, and he implicated Mr. Stillwell, or he implicated Mr. Williams, etc. It used to be that there was an instruction given, go back to common law, that can only be used against Mr. Kendrick. And the court said, that's not good enough. In a joint trial, the jurors can't be expected to follow that instruction. It's you said it earlier too, presumably the jurors follow the instruction all the time. That's what we presume. But in Bruton, that's why we excise or redact. And here, it is an essential element of this conspiracy in count 1 and several of the gang counts, then YSL is a criminal street gang. And now you have, and that's what I was saying before, and I'm looking for the cases.
Right.
But for Mr. Kendrick to get up and say, not get up, but for his plea colloquy to say, I am a member of YSL's criminal street gang, that instruction has to be airtight, otherwise he needs to be severed.
I mean, I agree that the instruction needs to be airtight.
Or he needs to be severed, or it's excluded. And I gave you a case when you first came on the bench here. I gave you, if you remember, if you know, I could give another copy. United States versus Vendetti, VanDetti, I gave it to everybody, or at least it's on the court in the state, and I think Mr. Weinstein, it's 623 F second 1144. It's the Sixth Circuit. It's 1980, it's good law. And I also cited State versus Jefferson, which is 302 Georgia, 435. That's 807 Southeast 2D, 387 2017. And they just stand in State versus Thomas, THOMAS, 364 Georgia Appeal 148, Division 2, 874 Southeast 2D, 195 2022. But the bottom line, Your Honor, is I would agree with the Honorable Maxwell Sharp that a instruction for that type of, that is explosive evidence that goes directly to the essential elements. So I do not believe that instruction would cure any type of fair trial for the other people in this case.
Just briefly, Your Honor, we would object to any severance at this point in time in the case.
I mean, I've read Vendetti, and I don't think that it actually stands for the proposition that you're arguing it for right now. I looked at the other two as well. The guilty plea of any non-testifying co-defendant can't, it's not proof of guilt for any of the other co-defendants. I mean, I agree with that, but that's not what it would be offered for. Y'all, the state, need to come up with an instruction that you believe will insulate the admission of the plea colloquy, the part that you intend to, where if he says, yes, YSL is a gang and I'm a member of it, from any brutish type problems.
Yes, Your Honor.
And we need to do it at, before that's admitted, not just at the end of the trial. It needs to be provided to the jury at the time the evidence is admitted.
Understood.
But, I mean, I don't think that the law provides that it needs to be excluded, just that it needs to be appropriately limited. And if you can find other law, please forward it to me. But I don't think those three do it. And let's see, so Thomas, give me those two sites again, just let me make sure I wrote them down correctly. I think you said 302 Georgia, 435
Yes, that's State versus Jefferson,
Jefferson, okay.
2017, and then State versus Thomas, 364 Georgia Appeal 148, Division 2.
Yeah, got it. Thank you, yes.
Moving offer as well, Henderson, just for the court's consideration. Henderson v. State, where the Supreme Court case decided August 21st, 2023, 317 Georgia 66 at
Is that a new one or have y'all given me that before? Okay, all right, I'll take a look at it. Okay. So you think y'all may have? All right. For a different reason, okay, well, I'll take a look at it for this reason. All right, so, we're gonna need to do some work on that one, but those are, I think we understand the parameters. Okay, so I don't know what, I mean, thank you whomever raised that, but in terms of going through what other evidence we need to look at, in this first 30 witnesses. The next witness that is on y'all's list in order to generate order is, Mr. B. Is there anything from him that we need to look at? I think, yeah, no, okay, so no social media from him? I didn't even see him in this folder, but. No, okay. And then there's, Kenya Morton, and there's maybe an interview from her, I don't know, if you.
Her interview would not come in
Okay.
unless she's listed as as the alibi witness for Mr. Kendrick.
Okay.
And we wouldn't be putting in her interview unless it's in future.
All right, so we don't need to look at any evidence that's gonna be used with her, right? Okay. Then Sprinkle, is there anything we haven't already talked about for him that? Yeah. So he's got a folder. If y'all wanna open up his folder. And then within his folder are lots of folders. So hopefully the defense has, in the couple of weeks they've had the folders and months and months that I guess they've had the evidence, made a determination as to what, if anything, y'all would be objecting to in this grouping of evidence.
I do have objections, but there's a lot here, so I don't. We can discuss certain things, as Your Honor sees fit. I will say I do have objections in this folder though.
Okay, well, now's the time to go through them while we have some days without our jury.
Yes, Your Honor.
So let's dive in.
Okay,
Where shall we start? We've got an Arnold file, or two Arnold files, Garlington, Kendrick's, other items, Stillwell, and then some, I don't know, looks like pictures maybe. Let me ask this, is there something that y'all are more ready on and then we can dive into this tomorrow? Would that help?
here. Can I discuss?
Sure.
When you're finished, we can make an announcement on the Marquavius Huey motion in limine, so get that off of our.
Okay. We'll wait till after they confer.
But we just have this also.
Sure, why don't we just take a quick recess, that way if anybody needs to use the restroom, y'all can talk, and if anybody else needs to use the restroom, they can go use the restroom. Okay. And Okay, before we move on to whatever we're gonna move on to next, somebody kindly sent me the, state 60 WA, I guess, that's already in. And I've only gotten through about half of it, but so far I don't see how the item number 14 from Zachary's folder, is cumulative of what is shown in that video, and it may be in the part of the video that I haven't seen yet, but can somebody pinpoint for me? Can we pull it up and maybe y'all can tell me what part of that makes this other potential exhibit cumulative? And I do not want to watch the whole video. I mean, I just, what's the part that the defense is contending makes Zachary's exhibit, I don't know what the exhibit number is, but the item number 14 cumulative? Yeah.
Ledge, you asked if there was another video that showed the display of handguns and quote unquote gang associated
Right,
verbiage and
right.
things of that nature that tended to show associations with whatever we want to call YSL.
Right.
Using the word slab and slime and things of that nature and displaying of handguns.
Mhm.
And that, our point was that the state has admitted, I believe this is, since 5 minutes long, I remembered it being longer than that,
Oh,
but,
it's longer than that,
oh, okay,
because I watched it for 5
okay,
minutes.
yes.
The version, so the what was admitted was shorter than the original version.
Well, that's merciful for the jury.
Right, so I mean, my point was, we've had these types of videos introduced before. My intention was not to suggest that it was identical
No,
or
and I know that,
exactly
but I
the
mean,
same.
I wasn't seeing a whole lot of like guns in the front of the camera kind of thing, and this, they're just standing around in a parking lot saying things and what have you, but.
And the only portion that I believe has a gun, one of the co-conspirators, Walter Murphy, I think the line is, he just got out last night and he keep the strap on him and he lifted up his shirt. He didn't point it at the camera, he just lifted up his
Well,
shirt.
and maybe I didn't get to that part of it yet, but let me go back and look at the item we're talking about again, but it seemed much more kind of the whole point of the video, so. Sure, yeah. I guess.
My whole crew got blood. YSL D, bitch. Slide shit. Yeah, ho. Right, motherfucking playing, ho. You have real big bullets, bitch. I ain't play with, ho. Yeah, ho. That's like the bodybuilder. What they doing? That's like the bodybuilder, my motherfucking big bro snake.
Yeah, I'm gonna allow that in.
Wanda, did you receive 2 videos or just one?
Just now of the 60 whatever,
Yeah, 60 WA, I think it was.
yeah,
There was a second one that was sent as well that actually had it.
okay, now I've only looked at one of them.
Yeah,
How about we look at the one that, was one of them redacted and one unredacted, or are there 2 different?
no, they're 2 different videos.
So one was 60 WA,
Yes.
what's the other one? Whiskey Alpha, I need to get used to that.
It was stated that I don't know offhand
Hang on.
the exhibit number.
It's on Google Drive. Oh, yeah, no, I'm just now getting that. So, if that went to, I mean, I guess I can pull it up, but I don't seem to be able to play the sound. So do y'all want to pull those two up? Because I guess they're now contending that.
Yeah, and just to kind of lay the groundwork a little bit,
Yeah.
Judge, the second of the two videos that was sent, show, it has Mr. Williams, with the handgun, it has, someone named Mondo, it has Buck Buck, the person who was referenced previously, who has a handgun displayed in the video, and it also has, another person you've heard named Fatty, outside of a house. It's a shorter video, but it has, the images that the court.
All right, well, let me take a look at it.
Yes.
Sound like y'all had a good time. Sound like it was a good, fun trip.